Hello everyone, my name is Natalia. I work as Sumsub's Artificial Intelligence Compliance Specialist, and my mission here today is to help you to decode a little bit of this world that is fascinating, although can be a little bit confusing, about AI regulation.
The lack of transparency can undermine public trust. This is not the future we want. You might have thought that voice was mine, but in fact, the audio was an AI voice cloning software trained on my floor speeches.
Some experts estimate there is roughly 200 ethical guidelines and frameworks about how companies should be handling AI risks right now. This mushrooming of guidelines and frameworks can leave many companies up to their own fate and create a lot of noise, which is even louder these days with the also mushrooming of AI regulations. So the goal of this video is to help you understand a little bit of the regulations you as a company should be keeping an eye on. This is the first video of a series of 2 videos where we are going to be exploring AI regulation. In the first part of the video, we are going to take a step back and look into a little bit the basics of AI regulation and try to understand why AI needs to be regulated in the first place, what are the challenges in regulating AI, and ideally how this should be done. Then we are going to focus today a little bit on the regulatory framework of the European Union. In the next videos, we are going to be talking about the United Kingdom, China, or the United States. And let's go. In its most primitive sense, artificial intelligence refers to an interdisciplinary field. As a discipline, AI includes many techniques that we are all very familiar with right now, such as deep learning, machine learning, so on and so forth. However, when we are talking about AI regulation, we are not talking about regulating AI as a discipline. Actually, we are talking about regulating systems that are created using the techniques of this discipline, so for example, AI systems, or the models that are embedded into those systems, the so-called AI models. There are many technical definitions out there about what are AI systems or what are AI models. But today we are going to stick with the legal policy definitions. According to the OECD, an AI system is a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. The EU AI Act, on the other hand, also helps us to understand a little bit the dynamic between AI models and systems. So what the EU AI Act says is that although AI models are essential components of AI systems, they do not constitute AI systems on their own. AI models require the addition of further components, such as, for example, a user interface to become an AI system. AI models are typically integrated into and form a part of AI systems. So when we talk about regulations, we are talking about regulating AI systems or AI models. And generally, AI models are inserted into AI systems. For example, the model GPT-4 feeds the AI system ChatGPT, which is the system we all have an interface with.
The partnership that OpenAI has with Microsoft is to shape this technology into something that's going to be useful for the world.
So when we talk about the European Union AI Act, the subject of the regulation is not AI, but rather AI systems or generative AI models. Why AI needs to be regulated in the first place? I'll invite you to go a little bit before and think about other emerging technologies. Historically, when is it that the state intervenes with the development of a technology? It's usually when this technology becomes too powerful and it starts to interfere with state's core competencies, which means basically the safety of people and also the distribution of resources. So let's take an example, social media. From the moment social media came into being to the moment where social media started to be regulated, and as an example of that, we have the DSA that just came into force. This was a period of roughly 20 years. It first took social media to start being a technology that is sufficiently powerful and starts infringing on people's safety, so for example, people's mental health or physical integrity, and also take the moment of social media to reshape economic relations up to the point it interferes with resources distribution. So technology regulation doesn't happen in the blink of an eye. It takes a while from the moment the technology is created to the moment the technology becomes too powerful. From the moment the term was first coined in 1955 up to now, AI has been gone through what some calls AI winters, where there is essentially a drought of investments in the sector and nobody talks about it. Since the rise of ChatGPT, AI has become a topic even increasingly popularized, and everyone talks about it all the time. And this time we have good reasons to believe that AI has come to stay. AI can easily threaten people's safety if you think, for example, on automated weapons. This reliance on AI is not a harm per se. What this reliance shows us in reality is that AI is not simply a tool. It's not a matter of something that is simply technical, but actually a phenomenon that influences our daily lives and therefore need to be discussed and shaped in a way that reflect humans' preferences, cultural values, so on and so forth. Hence the increasing amount for calls for AI regulation. And hence the need for companies from now onwards to stop treating AI as simply a tool, but actually something that also belongs to lawyers, policymakers, and not only to data scientists. When we talk about AI challenges, there's one that is the most famous one, the most discussed one, which is when should the state intervene into AI development? In 1980, the professor David Collingridge, he gave a name to this concern. He created what today we call the Collingridge dilemma, which states that when a technology is in its beginning of development, you can control it, but you cannot foresee the risks this technology will present, meaning that you don't have scientific evidence on how to intervene and prevent those risks. On the other hand, when the technology is fully developed, you can see the risks it presents, but you can no longer control it, and any measures you can try to apply might become innocuous. The first part of this conundrum is well known. Those against regulating AI usually argue that regulate AI now is to jump the gun, is to stop development when the technology is not fully mature yet. The first idea is that this argument that regulating AI now is to jump on the gun, I think it fails to understand the fact that regulation these days can mean so much more than simply state coercion or limitation. There are many types of regulatory frameworks these days that are increasingly business-friendly, allowing for self-regulation or regulatory sandboxes. The question of the potential of regulations to stifle innovation is something that EU lawmakers have been talking constantly and trying to portray that the EU AI Act will actually incentivize AI development and AI usage because it creates certain standards and gives certain legitimacy to the technology. The second way is the fact that at the end of the day, there never is a perfect time to regulate artificial intelligence. And this is simply because of the fact that the technology will be always and constantly moving in a very fast pace, while regulations can only change incrementally or marginally because political processes tend to take longer to develop. So this means that what regulations can do right now in order to try and solve this dilemma is to be future-proof. This has an appeal to the precautionary principle, where the focus of the regulation is at predicting and preventing harms. And a way of the precautionary principle to be manifested is through risk-based regulations. Risk-based regulations, they have the benefit of tailoring the regulatory burdens to the potential impact of certain risks, in a way that the cost of compliance for those subjected to the regulation is reduced. And this approach overall gives the regulations an innovation-friendly spirit or a future-oriented approach. This is the chosen approach for the EU AI Act, for example. So in the EU AI Act, the compliance costs vary according to the complexity and the risk of AI systems. If we understand that there are good enough reasons for AI to be regulated, then there is one very essential question: how AI should be regulated. Many countries, many jurisdictions regulate AI in many different ways. While the UK prefers to delegate oversight to AI to existing regulatory bodies in what we call a vertical approach, in which The consumer authority will have its own regulations, financial authority its own regulations, so on and so forth. The EU, on the other hand, prefers a cross-sector approach, which is the case with the EU AI Act. So while the EU is about to approve, to enter into force the EU AI Act, which is a very comprehensive and consequential regulation, other countries such as the UK and the US prefer this business-friendly approach, where they have issued so far mostly guidelines and risk frameworks on how to manage AI. But both these countries, the UK and the US, they still lack a comprehensive AI regulatory framework that is binding and applicable to the private sector. And lastly, another way where jurisdictions can find different answers to AI regulation is the comparison between China and the European Union. Because even though those two jurisdictions, they tend to adopt a very hands-on approach when it comes to tech regulation, the EU, through the EU AI Act, regulates AI in general, so the technology as a whole, whilst in China, the country has preferred to regulate AI applications one by one. So for example, one regulation deals with synthetic media, another one deals with recommendation algorithms, and another one handles generative AI. There are many regulations out there that companies should already be paying attention to. So for example, the GDPR already affects, in many ways, the ways that companies can use data, processing data for training and validating their AI models. So before we analyze the EU AI Act, we are going to talk about at least some two regulations that affects AI, which are the DSA, the Digital Services Act, and the DMA, the Digital Markets Act. The DMA was conceived to bring more competition to the European digital market. In its Articles 5, the DMA established information sharing obligations to reduce information asymmetry between gatekeepers and other players. This requirement implicitly demands gatekeepers to use explainable AI systems, and so creates an obligation to deliver explanations for each individual decision. This need to have explainable decisions and have technical documentation kept up to date when it comes to your AI systems is one of the main points of the European Union Act, to ensure transparency, explainability, to make sure that everyone can understand how decisions are made and how algorithms work. Article 6 of the DMA allows search engine operators to access the dataset of a gatekeeper search engines to optimize their own AI models. Also in Article 6, the DMA prohibits gatekeepers from using non-public business user data for AI-based inferences. Here, the DMA indirectly prevents additional improvements of gatekeepers' models, even if on the grounds of competitive law. The last video in our channel is actually about the DSA. If you haven't looked at it now and you want to know a little bit more about it, please have a look. So the DSA demands, for example, transparency and algorithmic accountability, meaning that all online platforms must publicly report how they use automated content moderation tools and those tools' error rates. The idea here is to show that, first of all, AI is not an unregulated field. If your company is somehow subjected to the DMA or to the DSA, you should already be aware of transparency requirements and explainability requirements regarding your AI systems, and understand that the joint impact of the EU AI Act, the DMA, and the DSA is bound to be significant for the industry. What is the EU AI Act in very general terms? The Act is the EU regulation that lays down harmonized, standardized rules for AI systems and generative AI models that are placed, made available, or put into service in the Union market. The Act was proposed by the European Commission in 2021, when many regulations related to the tech world were proposed and or approved, such as the case of the DMA or the DSA. The Act is now set to become law in 2024 after a political agreement was reached around it by the European Parliament in December 2023 and after the Committee of Permanent Representatives unanimously endorsed it in February 2024.
The law is going to take effect gradually over the next 2 to 3 years. And along the lines, we're going to increasingly feel the effect of those laws. For example, for the two of us living here in the European Union, we will have a right to know whenever we interact with an AI system.
Upon approval, the Act will be published in the official journal of the European Union and enter into force 20 days after that. The Act has hundreds of pages, so let's start about who are those that are subject. They call, in general, all of those that are involved in the AI value chain as AI operators. It is applicable to providers, to deployers, to distributors, and to importers. The Act also admits the possibility that a single operator can have many roles. You should fulfill all the obligations in all the roles of operators you play in a cumulative manner. Similar to the GDPR, the EU AI Act also has extraterritorial reach. So you need to understand if you are a provider, a deployer, or importer of AI, because that has tremendous impact in which compliance obligations you have to fulfill. A good way of making this exercise is to create an inventory of all the services and products your company provides that are embedded with AI systems or AI models, and ask yourself, what is your company's relationship vis-a-vis that system or model? Coming now to one of the most famous parts is the risk tier approach it follows. And the classification has essentially two tiers. It separates between those systems that are prohibited and those AI systems that present high risk. On a second level, it also differentiates between generative AI models that are, let's say, normal from generative AI models that present some type of systemic risk. So the systems that the European Union ban under any circumstances are described in Article 5, and the rationale of why these systems are prohibited is contained in Recital 15. What Recital 15 tells us is that, aside from the many beneficial uses of artificial intelligence, that technology can also be misused and provide novel and powerful tools for manipulative, exploitative, and social control practices. Such practices are particularly harmful and abusive, and should be prohibited because they contradict Union values of respect for human dignity, freedom, equality, democracy, and the rule of law and Union fundamental rights, including the right to non-discrimination, data protection, and privacy, and the rights of children. General examples of prohibited AI systems include the use of real-time remote biometric identification in public spaces, social scoring systems, AI systems that use subliminal influencing techniques, and/or systems that exploit vulnerabilities of specific groups. If your company develops any of the systems, they are not allowed to be put in the market, be put into service in the European Union. Moving now to one of the heated points of discussions in the Act is the risk tier that relates to high-risk AI systems. They are allowed to access in the European Union to be put into place, but only if they abide by certain regulatory requirements. The list of high-risk models, they are contained in Article 6. They give you some criteria to try to understand how to identify a high-risk AI system. But then in Annex 3 of the Act also provides a comprehensive list of examples of use cases of AI systems that it is considered to be high risk. Annex 3, which has this spelling out of high-risk AI systems, it was conceived to be flexible. Up to 18 months after the Act has come into force, the European Commission should issue guidelines to aid the practical implementation on how to identify systems that are high risk or not. This is also the type of exercise that when you do your AI inventory, as I recommended for identifying, which type of operator you are, in that exercise of the inventory, you should also try to identify if your system presents the characteristics of a system labeled as high risk under the Act. The last risk classification that AI operators should be aware of is related to the identification of generative AI models that represent systemic risk. It says that general-purpose AI system means an AI system which is based on a general-purpose AI model that has the capability to serve a variety of purposes, both for direct use as well as for integration in other AI systems. So a model that once put in place, it can help you to draft text or produce images or audios or videos and so on and so forth. You might also be asking yourself, how can I know if my model has this general capabilities nature? So the Act also offers a methodology to determine it. You can find it in Recital 60B, where it says that models with at least 1 billion parameters and trained with a large amount of data using self-supervision at scale should be considered as displaying significant generality and competently performing a wide range of distinctive tasks. Which of these models could be considered of presenting systemic risk? The EU AI Act defines that generative AI models present a systemic risk are those which present actual or foreseeable negative effects in relation to major accidents, disruption of critical sectors and serious consequences to public health and safety, or any actual or reasonably foreseeable negative effects on democratic processes, public and economic security, and lastly, models that contribute to the dissemination of illegal, false, or discriminatory content. Here again, you might be asking yourself again how to distinguish one type of generative model from the other. So in this point, the Act also proposes a methodology to help you try and figure that out. And the methodology essentially correlates the idea that systemic risks increase with proportionally to model capabilities and model reach. So the methodology the Act proposes to make this assessment include an analysis of, and here I quote the Act, cumulative amount of compute used for training of the general purpose AI model measured in floating point operations. The Act established that an initial threshold of floating point operation should be set, which, if met by a general purpose AI model, leads to the presumption that the model is a general purpose AI with systemic risks. So this threshold is still to be set, but the idea here is that you're going to have a measurement in which you're going to be able to distinguish, again, normal generative AI models from those that can pose systemic risk. Other AI systems that do not follow in any of these categorizations, they are considered to be low risk. For these models, the Act does not impose any obligations besides transparency requirement in certain cases. So now we're going to dive a little bit deeper into the requirements for those systems that you identified as being high-risk AI systems. They are defined under Title 3, Chapter 2 of the EU AI Act. They include the obligations to: first, implementation of a risk management system, as described in Article 9. Second requirement is the need to ensure adequate data quality and governance. The third requirement is the need to draw up technical documentation before the system is placed on the market or put into use. The fourth requirement is the need to, once the high-risk AI system is in production, is being deployed, you should have automatic record of events or logs during the whole lifetime of the AI system. This is established under Article 12. The fifth requirement is the provenance of transparency and information on the AI system to its deployers. Then the second last requirement you have is the ensuring that the system goes through adequate human oversight when needed. And lastly, the high-risk AI system should also be ensured to have, or to be in compliance with, the highest levels of accuracy, robustness, and cybersecurity protection. Providers of high-risk AI systems, they need to implement a quality management system of ideally all the AI systems, but mainly those considered to be high risk, containing evidence, containing the compliance of all the requirements I just mentioned. And secondly, providers must also ensure that the AI systems go through a conformity assessment indicating compliance with the previous requirements. Providers must also draft a declaration stating that they are in compliance. This is in Article 48. And they also need to fix in their high-risk AI systems a conformity assessment certification. If the system is something physical, then you can just add the tag to it. Or if it is an online system, then you need to just put the type of marking online. When it comes to generative AI models, providers have a special set of requirements, as it is detailed in Article 52. The last risk tier we have are the providers of general AI models considered to represent a systemic risk. And for those providers, they have a different set of requirements on top of the requirements we just mentioned. For generative AI models with systemic risk, they need to comply to standards like we just mentioned. But if their models present systemic risk, then they have also another set of rules to abide. They need to have a performance of model evaluation in accordance with standardized protocols and tools reflecting the state of the art, including conducting and documenting adversarial testing of the model with a view to identify and mitigate systemic risk. This is the first requirement. Secondly, the providers of generative AI models with systemic risk must assess and mitigate possible systemic risks at the union level, including their sources that may stem from the development, placing on the market, or the general use of the general AI purpose models. They should also keep track of, document, and report without undue delay to the AI office and as appropriate to national competent authorities, relevant information about serious incidents and possible corrective measures to address them. And lastly, the last requirement applicable is that the providers of generative AI models with systemic risk, they must ensure an adequate level of cybersecurity protection for the general purpose AI model with systemic risk and the physical infrastructure of the model. To sum up, I think altogether, these requirements might sound quite burdensome, but the idea is that once the Act comes into force, there will be a grace period, which we will talk soon. And during this grace period, the European Commission or the AI Office will constantly issue guidelines and implementing acts that will help all the AI operators to make sure they are in compliance with the dispositions of the Act. For the business who do not want to wait, the International Standards Organizations, ISO, already provides many standards that can be helpful. So the ISO has standards about governance, about risk management. The ISO also provides standards on how to have common approaches to terminology related to AI. And one of the most useful standards, I would say, is one standard that was released in December 2023. So it's a standard 42001. And this standard, it sets requirements for the implementation of an AI management system. This standard was conceived to be a facilitator to being in compliance with regulatory requirements, especially the EU AI Act. The standards requirements, they go around risk management, technical documentation, governance, and they are highly correlated with the requirements of the EU AI Act. Plus, this standard is also certifiable, meaning that being in compliance with it can award your company ISO Artificial Intelligence Management System certification, which gives extra confidence and extra trust on the quality, safety, and trustworthiness of the AI systems and models your company deploys. Now we are going to move to a very special set of requirements that are the transparency requirements. They are applicable to any AI system that, according to Article 51, is intended to directly interact with natural persons. These systems, they shall be designed and developed in such a way that the concerned natural person, so the person that is interacting with the system, is informed of the fact that they are interacting with an AI system. So it's transparency in the sense that when you are handling an AI system, you should know that behind that system, behind that interface, you have an AI technology. When it comes to providers of systems that can generate synthetic content, and that can be image, video, audios, and etc. These providers shall also ensure that the outputs of their AI systems are marked in a machine-readable format and detectable as artificially generated or manipulated. So this is essentially the practices of watermarking, where in the development stages of an AI system, you teach the algorithm to mark the outputs of that system as being artificially generated in such a way that when the output is produced, when the output is out there, another algorithm can learn that, can read that marking and flag, showcase that the content in case is AI generated. Let's try to understand a little bit how the Act will be implemented. So, as I said in the beginning, the Act will be implemented in the 20th day after the publication in the EU official journal, and it will be completely effective after 24 months, even though there are some exceptions to it as established under Article 85. So what are the exceptions? When it comes to the prohibitions of AI systems, so those systems that are outright prohibited in the Union, those provisions will apply 6 months after entering into force. So for any provider, any AI operator of a system that is prohibited, that person has 6 months to stop operating that AI system. General purpose AI models, on the other hand, are given 12 months or 24 months if already on the market to be in compliance with the requirements established for general purpose AI systems. And lastly, obligations for high-risk AI systems, as per defined by Article 6 and Annex 3, the applications, the requirements applicable to them will apply after 36 months the Act has been into force. As I said, the Act also comes with the provision that a new enforcement authority will be instituted. That is the AI Office, which by the time we record this video is already launched. The Act also stipulates that each member state is expected to establish at least one regulatory sandbox within 24 months of the EU AI Act being into force. So this means that in the next 2 years, there will be a lot of opportunities for innovation in the form of regulatory sandboxes that companies should keep an eye on. These are the parts, as I said in the beginning, that companies should really pay attention to when first handling the EU AI Act. So trying to understand which type of operator you are, which type of systems you have, and where do they fall in the categories of risks, and mainly the requirements that are applicable to you. And a little piece of advice, also try to understand which other regulatory frameworks besides the EU AI Act your company might be subjected to. And of course, as part of that, you should read Annex 3, because Annex 3 of the EU AI Act provides a comprehensive list of systems that are considered high risk. Just bear in mind that that list can be always updated by the European Commission. In parallel, make sure that while you conduct all these actions, so first the regulatory mapping and second the AI inventory, make sure that while you are doing so, you create a well-defined and diverse group of people who can take accountability for the company's AI systems and models. These would be initial steps towards AI governance. You should identify who in the company should be involved in this project. But when it comes to the EU AI Act, the main message is, if you are an AI operator, it is never too early for you to start thinking about the compliance with this regulation. That was it for today. I hope you liked the video. I hope that, as I said in the beginning, this deep dive into the EU regulatory AI landscape helped you to make sense out of some of the guidelines and frameworks you see out there. If you liked the video, don't forget to leave your comment and like us, and see you the next time.